Welcome. Today we will be commenting the CNIL's decision number 2020-002 from 9th of January 2020. The CNIL is the Commission nationale de l'informatique et des libertés. It is a French data protection authority. On the 9th of January, the CNIL took a decision about a project from the Ministry of Justice called DataJust. DataJust is a project of an algorithm that would be built in 2 years maximum and that would list the amount of damages received by victims in case of physical harm in last instance decisions. It will collect data listed in Article 2 of the decree, which contain names that will later be partially anonymized, previous condemnations and financial situations. All those are considered to be sensitive data and will be extracted from past and present archived judicial decisions. The claimed purpose of DataJust is the post-evaluation of policies in courts, aid in judge decision-making, establishing an indicative referential for similar cases, and helping victims to make accurate expectations. So the first question is, what are the CNIL's prerogatives in this case? So the CNIL was established in 1978. By the Act number 7817. In Article 2 of this Act, there is a list of competences of the Commission. So here we have the Ministry of Justice, which is a public authority that requests, as stated in subsection 2D, the Commission to give an opinion on DataJust. So here we have all the elements that allow us to say that the Commission, the CNIL, is allowed to give its opinion on the decree. In this video, we wonder what is the legal issue with this opinion. We will particularly focus on two main issues: Article 14 with the right to be informed and Article 21 with the right to object. The first issue relates to the right to be informed in Article 14 of the GDPR. Article 6 of the decree invokes Article 14.5 of the GDPR to derogate from informing data subjects that their data will be collected, on the grounds that it will create disproportionate efforts on their part to have to inform each and every single subject, taking into account the fact that all the informations have been pseudonymized before they arrived at the Ministry of Justice. Instead, the DataJust project plans to inform all subjects by putting a disclaimer on their website. And for those whose data will be collected during their trial, which has yet to happen, information will be included in court documents. The CNIL came to the conclusion that yes, this duty would require a disproportionate effort from DataJust because of the pseudonymization of data. The derogation to the right to be informed allowed by the Commission comes with the condition that the alternative ways to inform the data subjects are clear and understandable, as stated in Article 12 of the GDPR. The second main issue is the right for data subjects to object to their data being processed. Usually, anytime a controller processes data, the data subject has a right to object to the processing under Article 21 of the GDPR. But, under Article 23 of the GDPR, member states are allowed to introduce possible derogations to this right. France did take such a measure, allowing for a derogation under Article 23. This derogation is contained in Article 40 of Law number 2018-493 of the 20th of June 2018. Article 6 of the decree invokes the derogation on the grounds that there is a general public interest to access legislation. The Commission agrees that since the data was contained in public court decisions, then it counts as legislation and there is a general interest to access it. It is allowed for a measure to derogate from Article 21 under the condition, as stated in Article 23, that it still fulfills safeguards. The first of them is that the measure respects the essence of fundamental rights and freedoms. On this subject, the Commission decided to take no further observations. What we can still point out is that the rights to modification and limitation can still be exercised by the data subjects. And that be enough to say that the measure was not going against fundamental rights and freedom, but had a legitimate reason for one of those fundamental rights not to be fulfilled. Another safeguard is that the measure is necessary in a democratic society. The Commission studied the purposes of the DataJust algorithm and considered all of the goals to be legitimate except for the first one, the retrospective evaluation of public policies, and claimed that it was too vague and it was not sure that this would be in the general interest and not just in the court's interest. However, the overall goal is also to harmonize decisions and counter the known drifts and differences in damages amounts depending on the courts. It is a dangerous drift and a legitimate goal, and in this case, the Ministry of Justice would be acting in its capacity to make justice more fair. Finally, the last safeguard is that the measure needs to remain proportional. The measure plans to collect personal and sensitive data, which is quite intrusive. There is the possibility that the measure will lead to predictable justice and a lack of evolution in judicial policies. Those are biases that should be taken seriously and could possibly outweigh the necessity of such a measure. They were, however, not mentioned by the CNIL in its decision. The DataJust decree was therefore passed on March 27th with the approval of the CNIL on matters of protection of data and privacy.